Welcome, everybody. We're going to go ahead and get started. Welcome. Thanks for joining the webinar today on enforcement options for federal privacy law. An exciting topic for right now. It's January 2020. And we're going to go ahead and get started. A couple of housekeeping. We are recording this session. We're going to run for about 1 hour, which we will preserve plenty of time at the end of that for Q&A and discussion. And the slides and the video and any other content we have related to this will all be posted online afterwards at fpf.org/legislative-resources. And if you registered for the webinar today, we'll send you a reminder. If you're joining us today remotely, you're muted by default. But at the end, like I said, we're going to do a Q&A and we're going to take questions via the chat function in Zoom. So that's the best way to submit questions as we go along, and at the end is in the chat box, and we'll be monitoring that. If you happen to be joining us but via phone only, you have fewer options. You'll have to follow up with us or send me an email, and you're missing these great slides. So without further ado, we'll go ahead and get things started. A couple of quick introductory notes. This webinar is part of a series hosted by the Future of Privacy Forum. It's a series of legislation-focused webinars. You can find the videos and the slides of our previous sessions at this address right here, fpf.org/legislative-resources. And FPF, as most of you know, is a nonprofit organization. We have a mission of bridging the gaps between policymakers, industry privacy professionals who practice in the real world, and advocates and the academic community. And I should briefly say who I am, by the way. My name is Stacey Gray. I am a senior policy counsel here at the Future of Privacy Forum, and I lead our policymaker education and legislative outreach and analysis work, which there's a lot going on, as you know, in January 2020. And I also want to turn it over really briefly to our guest expert today to introduce himself. Nick, so glad to have you on the webinar today as an expert on this exact topic. You have a lot of experience here. Do you want to briefly say hello and talk about your background?
Yeah, thank you, Stacey, and also thanks to FPF for inviting me to participate today. So I am a private practice litigator at the firm Zwillgen. I'm a legal director here. For the past 10 years, I've mostly represented clients in complex litigation across a variety of areas, but including federal privacy statutes, class actions, constitutional privacy rights, and then I also counsel on issues in the privacy space and online gaming and other areas. I also deal with law enforcement demands for data. But briefly, I've been on both sides of the V, so to speak, and hope to bring some real-world perspective to some of these issues about how enforcement options play out in practice.
Awesome, thanks, Nick. And we're going to turn it back to you for some of these more complex litigation questions and have you involved throughout to talk about some of your experience and your expertise here. Just to briefly level set on why we're doing this and what it is that we're talking about today. Enforcement is arguably one of the biggest issues remaining for the passage of a comprehensive national privacy law. As you know, we have many sectoral privacy laws in the United States at the federal level related to children's privacy, health privacy, video privacy, and many others, many of which Nick has worked on. And what we don't have is a baseline comprehensive privacy law that would apply to all technology and all sectors related to commercial uses of personal information. So that is something FPF is very supportive of. Enforcement is a key issue there. Because I think most would agree that a good, meaningful baseline privacy law has to have meaningful enforcement. But the debate right now is really centered between sort of two extremes, with much of the politics centered around either arguing for just the FTC or another federal agency, but just a federal agency with all of the enforcement power, to the other end of the extreme of having kind of a full private right of action that would apply to all violations of the law with no additional harm or intent standards. And there are good arguments on both sides of this debate. There are a lot of really good policy arguments for and against private rights of action. We're not going to get too deep into those policy arguments today, but just to note that they're in the background, and some of them relate to the legal uniformity, the legal certainty, and the agency expertise that go along with having the FTC be the primary regulator in this space and enforcer in this space. And some of the arguments for the FTC are really anti-private right arguments related to litigation costs and the incentives that private rights can create, depending on how they're structured, to settle cases that might not have merit. And on the other side, advocates often note some of the important policy objectives of private rights that relate to access to justice, access to information through discovery, creates, as you can see in some of the recent news, a very strong compliance incentive, right? And involves judicial mechanisms rather than agency mechanisms for review. A quick note that a conversation is beginning to build around whether or not certain forms of individual redress are necessary for a comprehensive national privacy law to gain EU adequacy status for transfers of data between the EU and the United States. We're also not going to get too deep into that today, but just to note that that's out there as a possible policy objective, and we can talk about it more in questions if people are interested. So, what is it that we're here to do today? FPF, as I mentioned, is not taking policy positions on the right exact level of enforcement that's necessary for a federal law, but we have done over the past couple of months a pretty extensive review of existing privacy laws that we have in the United States, how they are enforced, and put together this webinar to kind of show an overview of all of the ways that one might think about possible enforcement, government, non-government, and everything in between, and how it might be structured. So what we're going to do today is spend the first 10 or 15 minutes or so talking about government enforcers, and I'll segue into a discussion of non-government enforcers and individuals and classes that might be able to enforce a law. And then I'm going to turn it over to Nick with his experience doing complex litigation defense to talk about specifically when you're looking at a comprehensive law, how you might craft it in a way that makes some violations of the law enforceable, creates a harm standard, creates an intent standard for companies when they violate a law. Some of those don't necessarily just apply to private rights, right? And then to talk about judicial remedies and other forms of individual redress, and then we'll leave time at the end. So that's our agenda for today. We're going to start off with, I think, the obvious place to start here, which is with government. And because we have been looking primarily at US federal privacy laws, obviously the FTC is a big player there, and this is kind of where we start thinking about enforcement options. The FTC, although it has some regulation authority for rules around COPPA, for example, is primarily a civil law enforcement agency. And most of the bulk of its privacy and security enforcement over the last 20 years has come from Section 5 of the FTC Act, which is a 100-year-old consumer protection law. So even though the FTC is not a judicial body, these cases are often still referred to as a kind of common law because companies look to them so closely when they look to FTC settlements to infer what the right business practices are going to be. The FTC has a variety of tools today at its disposal. Investigative tools to issue civil investigative demands, which are kind of like subpoenas with a little bit more authority to request specific answers to questions. It has what's called 6B authority, which includes the ability to conduct wide-ranging studies into specific things. And you've seen this, for example, a few years ago, the FTC launched a workshop on the subject of cross-device tracking, just for the purposes of learning more and informing the debate, and then issued a staff report on cross-device tracking. The FTC can initiate an enforcement action using either an administrative or judicial process, but most of the time it's administrative, and it's only when a company violates a final order that it is liable for civil penalties for violations. I can also refer, if there are criminal penalties involved, refer cases to the DOJ. Um, this is the setup we have now. The FTC has some relatively limited rulemaking authority under Section 5 and under its broad consumer protection authority, but most of the stronger Administrative Protection Act authority to create rules to sort of engage in further regulation fall under specific laws. A good example of that is COPPA. You see rulemaking every few years around children's privacy. So if we're starting with the FTC as our sort of first look at possible enforcement options for a privacy law, there are definitely some considerations that a US national law should take into account when considering the FTC as the proper enforcement body. So the first thing is, I would say, consider not just whether it's a good idea to have the FTC as the enforcer, which for a lot of reasons it may be, but also consider whether you specifically want your enforcement authority to fall under Section 5. Section 5 of the FTC Act is a consumer protection law. It includes standards through policy statements around what constitutes unfair and deceptive practices. So if, for example, a federal privacy law were to define any violations of its terms as a per se Section 5 violation, then you might be needing to consider whether the law will be limited, or to what extent you want it to be limited, by the existing standards for unfairness and deception. So for example, the unfairness standard is a well-known three-part test where a business practice is considered to be unfair if it's likely to cause substantial injury, not reasonably avoidable, not outweighed by the benefits. This is kind of a holistic, factor-based standards test for consumer protection that limits the ability, I think, to bring certain cases in privacy situations, and has really primarily been used for security vulnerabilities. You also would likely want to consider whether to add civil penalties or other forms of consumer redress in the first instance of a violation. So right now, a company would have to be under a final order and a consent decree from the FTC and then violate it in order to receive those high penalties that we've seen in the last few years. Broader or targeted rulemaking is likely going to be an appropriate addition to existing FTC authority. Funding and staff, of course, come up a lot. The FTC, if it's going to be the only regulator in this space, has to have the appropriate funding and the staff. Other things that are a little more novel might include, for example, mandatory complaint resolution, which is something we'll talk about a little bit more towards the end of this webinar. And then I think a big one that comes up a lot is it's possible to add the addition of state attorneys general or other local entities as additional enforcers who can bring actions. That is something that we have under the Children's Online Privacy Protection Act, but does not exist under Section 5. So a quick word on state attorneys general. There are good policy reasons to include them as enforcers. There are some policy reasons to not include them as enforcers. Notably, state AGs have been very active in helping the FTC to enforce the Children's Online Privacy Protection Act. They often work very closely with the FTC to bring joint actions. Local enforcement would include things like city attorneys, state consumer protection officers, and so on. And regardless of what additional enforcers one might bring in for a comprehensive privacy law, one can structure the interaction between state or local enforcers and the FTC in various ways. So, and some of these you do see already under COPPA. So for example, you can require state AGs to notify the FTC prior to bringing a complaint. You can require consolidation when there are cases going on filed by several state AGs against the same defendant. Intervention is an interesting one because intervention is something that exists as a default, even if you don't write it in, and Nick can speak more to this, but exists as a default, even if you don't specifically draft it in a federal law. But what one might do is create by statute the absolute right to intervene so that it's no longer a question of fact as to whether the FTC has the appropriate interests in the case. You could also prohibit AGs from instituting actions while there's an ongoing FTC action, right? And sort of going on down the line through this list, from lighter touch to kind of more restrictive, at the end of the list, I might note that a much more restrictive mechanism that we don't see under COPPA, but that you might consider, is to require AGs to explicitly seek approval from the FTC to bring civil actions. Taking us to non-government enforcers, a couple of things to note about civil actions. A federal law could permit individuals to sue on behalf of themselves or others to challenge violations of a law when they are affected by the violation of that law. Class certification is something that will be available by default under Rule 23 of the Federal Rules of Civil Procedure. It's not something that you have to specifically write into a law, but it is something that you could limit or eliminate through law, right? But if it isn't written in, then class certification is subject to Rule 23, which involves a 4-part test of commonality, for example, to ensure that the people actually bringing the lawsuit are sufficiently representative of the class. Similarly, organizations and nonprofits are also not necessarily something that have to be written in to a law in order for organizations and nonprofits to bring suit. And this is something that's been discussed in a lot of the proposals over the last year or so. Organizations and nonprofits are in many cases able to sue just because they represent a group of members, for example, that are affected by the law. Organizations still have to meet standing requirements, which are the constitutional minimum requirements to bring a lawsuit. And those look a little bit different for organizations, but it's kind of a default thing. And then in addition to that default, you could specifically promote nonprofit litigation through a federal law by establishing a framework for nonprofits to challenge violations. So you could create standards, processes for qualification, or just allow any 501c3 nonprofit to sue by explicitly allowing it in the law. It would probably still have to meet constitutional standing requirements, right? So that would probably just be privacy 501c3 organizations. Or a federal law could just defer this process to the FTC or state AGs or require them to appoint nonprofits. And again, a quick word about standing before we move on to some of the more complex topics. Standing is a constitutional requirement that has nothing to do with how you draft the law, no matter what. In order to bring a lawsuit in federal court in the United States, an individual or an organization has to meet minimum constitutional standing requirements. They must demonstrate that they have suffered a specific injury that is caused or traceable to the defendant and is likely to be redressed by a favorable decision. This is intended to prevent federal courts in the United States from issuing things like advisory opinions. There has to be a real controversy. Someone has to really have been affected by the violation in a way that can be resolved. So this applies to all civil actions, but for privacy violations in particular, it's a bit of an unsettled area of law. I think we have seen from a case called Spokio versus Robbins that a, quote, bare violation of the law is probably not enough if it's a technical violation that didn't actually affect you or cause any real specific injury. But in other cases, specific injury has been found to include violations of core legally protected interests, unfair profit, trespass. We saw this, for example, in some of the litigation around the lawsuit under the Biometric Privacy Act in Illinois against Facebook, right? So the specific injury requirements for standing involve privately, but it is still a bit of an unsettled area, which may weigh, for or against you on the issue of legal certainty. So I'm going to turn it over now to you, Nick, and we're going to talk about some of the specific federal laws in the United States that we've been looking at, and from your experience as a defense attorney here. Talk us through specifically when we're looking at enforceable parts of a law, whether that's enforced by a private right of action or whether it's enforced by the AG or enforced by the FTC or another agency. What are the different ways that one might craft violations of a law?
Yeah, absolutely. So as you were saying, at least when you were in federal court, and this varies a little bit in state court, but there's always a constitutional baseline, and in the privacy area that's been debated. I would say the results have been mixed following the Spokio decision, but there has been at least somewhat of a trend to recognize the sort of bare minimum constitutional standing wherever a statute creates a substantive right. Basically, the court will in some cases consider that good enough. And so I think when you're drafting affirmative legislation, an important thing to think about is to sort of operate around the assumption that a court could find any right created in that statute as potentially enforceable. And that, that can often be a pretty broad consequence, but there are ways in drafting a law to impose additional restrictions. And, another kind of framing point that you mentioned is thinking about who the ways that the standards you're setting interact with who the enforcer is. So a lot of times, and we'll go through a few examples of these, but you may want some ability to enforce most of the rights in a statute by the primary regulator or potentially some combination of government enforcers. But then to progressively narrow it or to set higher standards to avoid sort of over deterrence or bad incentives when it comes to private rights of action. So, courts generally recognize it's sort of called constitutional standing, and then statutory standing is additional requirements that are set out in a statute. A good sort of comical example of the difference of those is there was actually a Ninth Circuit case a few years ago called Naruto versus Slater, which some of you may have read about. It involved a monkey accidentally taking a photograph and then PETA sued on his behalf to try and get copyright infringement damages against a book publisher. And the Ninth Circuit actually found that constitutional standing was established for the monkey because the monkey had suffered concrete and particularized economic harms, but that the Copyright Act did not contemplate animals suing. And so in that case, it was probably not a difficult decision, but it emphasizes that the language that you're using about who can sue matters. So in an area like privacy, which is developing, it's somewhat uncertain, it's certainly fast moving, and it's always interacting with the edges of technological change. I think a harm standard is one gating mechanism for any kind of enforcement action, either the ability to bring an enforcement action at all, or the consequences and the kinds of damages and relief that can be obtained, depending on the type of harm involved. Some federal privacy-related statutes that have been enacted in the past have not included any meaningful extra harm standard on top of the standard you have to meet to get into federal court. A couple examples of those are the Video Privacy Protection Act, which protects video viewing information, and the TCPA, which regulates unwanted marketing-related phone calls and texts. The lack of any additional harm requirement there has made it very easy to file enforcement actions under those statutes, and the consequences of that, we'll cover a little bit when we get into remedies. There are different ways that you can look at harm standards and what kinds of thresholds you can draw. One is based on the category of harm. So a federal privacy statute could be protecting a lot of different kinds of interests, but some of those interests may not rise to the level of requiring aggressive enforcement in court. So you can draw based around a category of requiring that someone bringing an action show financial harm, that they show identity theft, that they show unfair discrimination or other kinds of adverse professional consequences. You can base it around disclosure, or misuse of certain subcategories of information. So that kind of ties into violations of core rights. It could be, you see this in the European context with special protections built around, certain sensitive categories of information like medical history and sexual activity. And I think the benefit of setting some sort of harm standard is that it filters out or limits the ability to bring cases where the harm is either amorphous or it's easy to allege if you're, for example, you're a private plaintiff, and you can, essentially there's not a test where a court can look at whether you can actually establish a particular kind of harm. It sort of lets a lot of things in the door. Can we move on to the next slide?
Sure. Sorry. There we go.
Oh, and briefly, the one other obvious harm threshold that can be established is based on a dollar amount. So a good example of this is the CFAA, a law that prohibits unauthorized access to computer systems. It allows civil actions, but it requires that you show a certain amount of actual loss. So it's $5,000 aggregate loss within a 1-year period, unless you can show something else like physical injury. So there are different thresholds. Harm is essentially looking at the plaintiff who wants to bring a lawsuit, whether it's a private person or it's a regulator on behalf of individuals. How do they have to have been injured? The other way to look at it, another sort of gating mechanism, is what is the nature of the defendant's action or the defendant's intention? This can be a useful function for gating litigation because it ties the ability to sue or the kinds of relief that you can get through a lawsuit to what you can show about the nature and the egregiousness of a defendant's conduct. And it can serve as a damper on sort of technical compliance litigation or gotchas over ambiguities that are difficult to anticipate in advance. So some examples are up here on the screen of intent standards and existing privacy litigation. I'll say that historically, their intent standards are often used to calibrate the kinds of damages that someone suing under the law can get. So for example, the Privacy Act, which is a law that sets requirements for federal agency handling of PII, allows essentially injunctive relief only. So being able to get a court to order certain kinds of mandatory behavior, you can do without showing a deliberate intent by the defendant. But if you can establish that the violation of the Privacy Act was willful or intentional, then you can also obtain compensatory damages. Under FCRA, the Fair Credit Reporting Act, it's a similar mechanic where you can get actual damages within a particular range when there's a willful failure to comply, and higher penalties when there's sort of a higher level of egregiousness. So it's obtaining a consumer report under false pretenses or knowingly without a permissible purpose. So the one sort of comment I will add from experience dealing with intent and knowledge standards in litigation is that drafting is important here because it's not always necessarily an effective filter. If a standard, for example, is knowing, so we can take the Driver's Privacy Protection Act here, which permits an action against an entity that knowingly obtains information. In the data privacy space, a lot of, and maybe most of the activity that's going to be scrutinized are actions that are knowing or deliberate in the sense that they are not purely accidental. They are the result of a system being built a particular way or a program being designed, to function in a certain way. But that is different from knowledge or intent to cause a particular result. So there's a difference between knowing that you were collecting data or that you were using data in a particular way versus knowing that or intending to discriminate, to re-identify someone who is de-identified, to intend to collect without consent. That's a distinction that's important to remember, that knowing in this context may operate differently than in other contexts. So I think here the Fair Credit Reporting Act is a decent example in the sense that it has an elevated penalty standard when not just you are intentionally taking the action, but you are essentially intending to obtain the report under false pretenses. So it requires a sort of state of mind that is negative, is what you are trying to deter by passing this law. Whereas if you can't establish that, then whoever is bringing the lawsuit might be able to get some other kind of relief, or it may just be something that is still subject to regulatory authority, but it's not the kind of thing that requires the involvement of, sort of the full weight of the judicial system. So should we move on to remedies?
We definitely can. I want to pause here because I think, Nick, we just covered a lot of material on 2 slides. First, I want to remind everyone that we're taking questions in the webinar chat as we go along. You're welcome to chime in if you have questions about anything being presented, in addition to reserving time at the end. And Nick, I just have one question for you, which is, can you speak a little bit to how intent and harm may interact with each other? I mean, we've seen some laws that have kind of a sliding scale where perhaps if there is demonstrable financial harm, for example, the intent is less important. But if there isn't, perhaps you need to show a higher intent standard, right? And then after that, I'll turn to a question in the chat.
Right. So yeah, it is a sliding scale, and it's sometimes difficult to talk about in the abstract without knowing what particular right is being implicated. I think, and sort of who the actor is. I think the type of harm, or the harm standard is again about, I guess, making a policy decision that certain kinds of actions warrant enforcement in court as opposed through other mechanisms for compliance. And I think thinking about incentives there, right, any sort of remedy that's created where that's potentially enforceable in court, it does create compliance incentives for a company. But from the standpoint of a regulator or a drafter of a statute that's hoping to incentivize the right kind of compliance and to try and focus resources in the right area, putting some of these gating functions can ensure that you are not overly targeting and directing sort of most of the resources and attention to something that the statute may enable someone to sue over, but isn't necessarily really what it's going after. It's not the worst conduct. It's not, the primary focus, and it's something that could be just as easily addressed by, a regulatory inquiry through a sort of less formal means, or through just a weaker form of relief, like being able to obtain an injunction as opposed to, providing for damages. So I think the harm and the intent standards both sort of accomplish that goal of in court enforcement is one tool, I think, in a toolkit, going back to the first slide of trying to debate between regulatory authority versus rights of action in court. These are ways of ensuring that that the mechanism is being used by the right people for the right ends.
Great. Thanks. And we have one question in the chat, since we've been speaking a little bit about injury in fact and standing. Many of the proposals that we're seeing have a statement that the draft bills in Congress, for example, have a statement in them that says, a violation of this act constitutes an injury in fact. In light of the fact that you have to meet standing requirements anyway, does that mean anything? Is that persuasive to courts to specifically write it into a statute?
I think the trend is that it is. So the Spokio decision that you talked about earlier by the Supreme Court a couple of years ago looked at this exact question of, the constitutional minimum is that you have to have suffered a cognizable harm. It has to be a specific and particularized harm that the court is equipped to redress. But in the context of injuries or alleged injuries that are not ones that were traditionally enforced in court to the same degree, and that are not necessarily particularized. So it's not financial harm, it's not physical injury, but it's something like increased risk of, identity theft or, loss of some sort of moral rights or personal rights in data that has, been exfiltrated improperly. It becomes hard for a court to know whether it is, whether it's redressing a real injury. And one of the things the Supreme Court looked at traditional privacy torts, like invasion of privacy, to get some sense of the kinds of things that courts have already recognized as enough harm to get you in the door, so to speak. But another thing that it looked at is for a particular, it essentially recognized that Congress has some ability, not unlimited ability, but some ability to recognize a particular harm as supporting relief. And so it looks to the intent of a statute and the kinds of rights that it creates, and it draws some delineation between substantive and procedural rights. So, a statute may say that it prohibits a particular kind of conduct at all, but it may, by a company, but it may also say the company, when it's dealing with your information, has to follow certain procedures. The violation of the procedures may not result in the kind of harm that they tried to prohibit with the other piece of it. And so it looks to what Congress is intending. And I think in the context of, for example, the BIPA, Biometric Information Privacy Act, the Ninth Circuit recently looked at this issue, and now courts have looked at this issue in the context of quite a number of different privacy statutes. And I would say the trend is that they have found, if Congress or even a state legislature intended to create a right for people to be protected from a particular kind of privacy-related harm or action, then the court's more likely now, I think, to let that sort of claim in the door, which is why I think it's important when including that kind of language to understand that potentially opens the door fairly wide, and to think pretty meaningfully about whether you need to put other restrictions in place, whether it's intent standards or harm standards, to say not just that anyone can get into the door in court, but you have to, we really only want to incentivize certain kinds of actions, and being explicit about that, because otherwise I think there's more of a risk now that including language like the question suggested would let in the more causes of action under a privacy law.
Great, thanks.
Okay, so moving on to judicial relief. So we've been talking about who can sue and what kinds of limitations can be put on really just establishing the right to sue. And there's a whole set of questions that are beyond the scope of this presentation about sort of what causes of action a statute would create, what kinds of violations can be prosecuted. The scope of those is an important question for sort of the meat of the privacy law. But another important element, and in a certain sense, one of the most important elements, is what kinds of relief can you get at the end of the day? This is really what drives cases, right? People, whether it's federal agencies like the FTC or state AGs or private plaintiffs and plaintiffs' law firms or public interest organizations, they're all filing cases because they want relief. And so I think understanding here, we're going to focus mostly on what is the menu of options that are essentially available that exist in the judicial system. But I think from understanding them from a drafting standpoint is important, because it lets you think about who do you want to have these different abilities. So going down the list here, equitable relief comes in different forms, typically injunctions and specific performance. And injunction is, just a fancy word for a court order that tells a company to stop doing something. The conduct that they have been found liable for violating. And specific performance is a little bit the flip side of that. It's affirmatively requiring defendant to take particular steps, commonly steps that they committed to taking but then failed to take under a contract or under representations that they made in a policy. And these are, I would say, so in the data privacy context, for example, it could be performance to comply with consumer erasure requests, data amendment requests, data access requests, or to implement reasonable security practices where it's been found not to have them. These are relatively common in federal privacy laws, and I would say in most consumer-oriented laws generally, and courts have some equitable powers to order relief, essentially to make sure that the person who came to court gets the relief they want to. And they are, I would say, a good starting point for being able to rectify the particular issue that brings someone to court without, in a very targeted way. Taking these, I'll take 3 and 2 out of order. Actual damages is sort of the most self-explanatory of these. It's compensation for either, again, it depends on who is suing, but if you're talking about an individual, then it's compensation for actual ascertainable loss that they can show resulted from a particular violation. If you're talking about a state or a federal regulator, then they can seek damages that are based on potentially the losses of the group of people under their jurisdiction. So it could be citizens of the state, or it could be even broader than that. Restitution and disgorgement, I'll just briefly cover, are an alternative to that exist in both the regulatory enforcement and in the private enforcement context, where instead of focusing on the harm or the loss to the plaintiffs, you are focusing on the unjust benefit or profit, from to the defendant as a result of the violation of law. So those are all those actual damages, restitution, and equitable relief, I would sort of broadly categorize as directly remedial in response to the violation that occurred and the consequences that flowed from it. Statutory penalties and punitive damages are sort of going outside of that a little bit into the policy and the deterrence context. So statutory penalties, which are included in some statutes, and I'll give a couple of examples, are where the law defines either a range or an amount or a formula for calculating damages that is not necessarily tied to any actual harms that can be shown or any losses. The justifications that I've seen for these are where damages can be difficult to measure or where there's a need to create an incentive for smaller claims that otherwise wouldn't be redressable. Statutes, these exist, for example, in the federal privacy context. There are statutory damages available under the TCPA over marketing calls and texts, under the Fair Credit Reporting Act for certain violations related to consumer credit information. The Video Privacy Protection Act has a statutory damages element for disclosure of video viewing information. The one thing this is where I deal actually with quite a few class actions involving statutory damages, and one thing to be very cognizant of in allowing this, often the intention is good, but it interacts with class action mechanisms that Stacey was talking about earlier, to create sometimes, very dramatic results. So I think Stacey mentioned this a moment ago, but in the news yesterday, the settlement involving the Facebook BIPA case, involved a statutory damages amount that I think was in the tens of billions of dollars, resulting from basically taking a number written into a statute and multiplying it by the number of people. In the context of data privacy and in the context of the internet more generally, it creates a sort of magnitude-based scale that is more related potentially to the number of users you have than the nature or egregiousness of the conduct or the financial resources of the company or other factors like that that a regulator, for example, might take more into account in trying to figure out what is the appropriate deterrence mechanism and sort of level of penalty here. And the other notable aspect to kind of transition into judicial discretion is that statutory penalties generally don't give courts a lot of discretion. There is sort of constitutional due process discretion at the margins to reduce penalties, but they generally don't come into play all that much. I think the pattern that you often see is these create so much leverage for private plaintiffs that they encourage settlement as opposed to fighting a case sort of all the way to the end. So that creates some limitations on courts' ability to actually fully explore sort of what are the limitations of some of these issues. So the last point here, judicial discretion is, and treble damages is an example of this, is a variant where you can take, for example, actual damages, but then create a multiplier usually when certain elements are met. So going back to when we were talking about intent standards, if you have a willful or an egregious or a deliberate violation, or you have a particular malicious intent, for example, an intention to discriminate, it allows a court to heighten the penalties to serve a deterrent effect and to sort of send a signal that this is really disfavored conduct, and both the target and others need to take into account that that kind of behavior creates increased penalties. The last thing I'll say here is just to sort of emphasize that a lot of these penalties, it's labeled under judicial relief, but equitable relief is very much sort of literally within the court's control. The way that federal courts work, judges have a lot of discretion, kind of are in the driver's seat when it comes to establishing equitable relief and how to shape it. Actual damages and restitution, in a lot of cases, if you're talking about what is ultimately a jury trial, it is actually a factual question for a jury to find. But again, it has some checks and balances on it. In some of the other areas, there is either more limited judicial discretion, or really the discretion is more in the way a claimant structures his claim. But I would just contrast it with the way you often see regulatory enforcement actions. If you look at ones under COPPA recently, FCRA settlements, just looking at the FTC, for example, and its sort of menu of enforcement actions, or enforcements for violations where it can get civil penalties, and those settlements are often informed by much more of a multi-factor approach to looking at the nature, the extent of the harm, the egregiousness of the conduct, and the situation of the defendant. I think the judicial relief menu doesn't always allow for that same level of discretion.
Great. We just have maybe one more minute for our last slide, and then we're going to have some time for questions. So we will move on to final thoughts. Yeah.
Yeah, so I'll cover this briefly, and then we can cover it more in questions if needed. But there's looking at who can sue, under what circumstances, and what relief can they get. But it's important to know that there are other mechanisms available that can sort of shape the role that courts and that litigation, either by regulators or by private plaintiffs, takes. And the policy incentives that creates, the ones that you're trying to encourage. So immunities, defenses, and safe harbors. There are examples of these that are pretty prominent in the news right now. Section 230, for example, of the Communications Decency Act creates certain immunities for third-party content platforms and for moderation efforts. There are there are protections in the copyright context, for example, for internet service providers, for platforms, for user content, where there's a mechanism to take action to, take down, for example, copyright infringing content, but without penalizing, and potentially just making it unsustainable to operate an internet service that third parties can interact with. So I think in the privacy context, you have to think similarly about who are the targets of the regulation and who are intermediaries who have a role to play, but not necessarily should have the same level of exposure in court. A related piece is a safe harbor, which COPPA is a good example of, allows for the FTC to certify a self-regulatory organization, and participation in that gives you a level of assurance that as long as you're following those rules, you have protection under the statute. Very briefly, heightened pleading standards are essentially allowing mechanisms. Litigation is expensive, even in the best of cases, and so there are some mechanisms that have been used in other contexts to allow someone who thinks that they really don't belong in court, this is not the type of case that belongs in court, to bring an early challenge to bad faith or to frivolous litigation. And an example is anti-SLAPP motions in the defamation context, where a lawsuit is filed that is really more to penalize someone for speaking than for genuine defamation. And a majority of states, I would say, have a mechanism for filing an early motion to get rid of those that actually is easier it's harder for a plaintiff to prevail than it would be in any other in sort of the course of a normal lawsuit. And it allows for really avoiding sort of unnecessary court costs. So there are a fair number of others here to cover, but I want to make sure that we leave time for questions. Stacey, should we pause at that point?
We can definitely pause. I think the last one is probably an important one to touch on when we talk about administrative exhaustion, because that can go along with private rights of action, but doesn't necessarily. So even if you didn't have a private right of action built into a statute, you might nonetheless provide for some level of individual redress through a mandatory complaint system or mandatory complaint resolution of some kind through an agency.
Right. Yeah, and those can be structured a couple of ways, either requiring, either as an alternative or as a prerequisite to filing a lawsuit as an individual. You could have a structure where someone has to file a report with the primary regulator, who has an opportunity to investigate it and to either decide to let it go forward as a lawsuit or to take care of it themselves. I think it makes some sense to have a mechanism like that, even if it's voluntary, in the context of data privacy, where a regulator is maybe better positioned is seeing the same question over and over and over again, maybe involving the same company and the same practice, has an ability to set a more coherent policy. And I think the grace period bullet point above is a variant of that, where you can allow people to provide complaints or questions to the company directly, and to allow them a window of time to respond and potentially cure the problem or address the issue. You can potentially pair that with some sort of notice to the regulator, but it creates mechanisms that don't carry all of the weights and the costs and the delays associated with litigation, where you can get individual redress, you can get some regulatory and some individual accountability, but encourage more effort, more focus on compliance.
Great. And is there a good example of that in existing federal law?
So as to grace periods, it is, I don't know if it's predominant, but at the state level, there are a lot of states that have a notice and cure period under their consumer protection statutes, where there has to be a statutory period of 30 or 45 or 60 days where you can tell a company about a particular bad practice and they have an opportunity to redress it. The issue with those can be that, drafting, again, as always, is important, because it can be easy for a plaintiff to write a complaint in a way that it's impossible to redress, where they're essentially just asking for the relief in the lawsuit. But, another example of more the mandatory complaint process is, for example, the EEOC, which is a different regulator in the employment context, but they essentially have a responsibility to investigate all reports that come into them and to provide some pre-clearance beforehand. And lastly, I'll note the CCPA's data breach provisions, which, you know, I think there are some concerns with from the private bar side, but it does include the concept of a pre-lawsuit procedure in which you have to provide notice, opportunity to cure, and that can provide protection against certain kinds of damages for a company that follows them.
Great. Thank you so much, Nick. We covered a lot of ground, and I want to pause here at the end for some questions. We've got a few minutes to take one or two. Okay. Great question in the chat about safe harbors, and I think I'm going to pick this one because I think it's very relevant to the sort of the ongoing conversation right now. Sure. Can you discuss further how a COPPA-style safe harbor might actually work as an enforcement mechanism in a federal privacy regime? Specifically, the guest is asking about the safe harbors proposed in Senator Wicker's discussion draft and the House Energy and Commerce discussion draft. What might that actually look like? It's a good question.
Yeah. So I have not had an opportunity to look closely at the sort of the framework that's laid out in those discussion drafts. I mean, I think the question really is again, always in the details, and it's going to depend on the scope of the territory that the federal data privacy law is trying to cover, right? Because there are companies that are in very different positions, and, you know, privacy versus security raise different sets of issues in different way, you know, different means for certification. So I think my sort of off the cuff thought is that you may need a framework that recognizes safe harbor frameworks that don't necessarily cover the entire universe of activity, but that are a little bit more geared to different industries or types of activity. And, you know, so for example, you know, ad tech, right, is the thing that immediately comes to mind, where there's an ecosystem and a certain set of behaviors, and there's sort of a framework that everyone has to agree on in order for the system to work, and it takes privacy into account as part of that framework. And so establishing a mechanism for those frameworks to be reviewed by the FTC and certified as a safe harbor are going to be very helpful to the ad tech space and people participating there, but are not going to be helpful necessarily to a company that is doing data collection in a completely different context. But if they're, for example, in the retail space or the e-commerce space, there may be a sort of situational framework that's developed within that industry that can also be recognized, and that isn't going to give you a safe harbor against every kind of conduct that the federal privacy statute covers, but it does give you assurance as to the things that you are actually doing. That's sort of my initial thought.
Great. That's very helpful. We have one question that I don't know if it's an easy answer or not. A participant asked if you can explain the difference between prohibitory and mandatory injunctions, which you'd be better positioned than me, and whether that matters, how that might play out for privacy violations.
So it is something that I would want to look at more closely. I mean, I think that's sort of the distinction that I was drawing between specific performance, or you could call it a mandatory injunction, versus prohibitory injunctions. There are, trying to think there, I mean, one thing that comes to mind is prohibitory injunctions are probably easier to write. This is something that you see in the FTC. For me, it brings to mind the data security enforcement context, where writing a prohibition is more straightforward, because your investigation or litigation is focused on is this particular activity a violation of the law, yes or no, and then you can say prohibit it. Whereas a mandatory injunction requires more of, I would say, policy judgment. And why I think of the FTC's data security practices is that they've dealt both internally as a process matter and in court with the question of how specific should they be versus how flexible should they be when they enter consent orders, for example, about what kinds of reasonable security practices you want to follow, because it is a prescriptive decision, and it's one where you don't want to necessarily have to be too specific, but you also want to be specific enough to ensure that you're achieving your compliance goals. So I guess my off the cuff thought is that is mandatory injunctions are something that are harder for courts and private litigants potentially to do, and to do the balancing acts that are required there. Although judges can exercise a supervising role, but it is the kind of thing where a regulator with concentrated expertise is probably better positioned to do and better positioned to keep up best practices as, what those best practices are evolves over time.
Great. Thank you so much. So we're at the end of the hour and a couple of minutes over, so I just want to thank everyone for coming. I think we could have covered a whole lot more ground even than we covered, looking to things like, for example, non-privacy federal statutes that we might learn from, like anti-discrimination statutes and how those are enforced. So Nick, we may have to have you back on a future webinar.
Yeah, we'll need another hour at least.
We'll need another few hours. Anyway, thank you all so much for the time today, and let us know what you thought, and send any other questions you have to the email here or to me directly, and I'll put my email in the chat as well. And everybody have a great rest of your Thursday. Thanks, Nick.
Yeah. Thanks, everyone.